Welcome, everyone. We're really glad that you're with us today. My name's Stephanie Summers, and I'm the CEO of the Center for Public Justice. And we're really pleased to partner today with the Christian Alliance for Orphans for this webinar on understanding the Fulton foster care decision, implications for faith-based organization. I'm going to give us a brief agenda for our hour together. I have a series of questions for our panelists, and then we're going to turn to your questions. So throughout the discussion, you'll be able to drop your questions into the question and answer portion of Zoom, which is located at the bottom of your Zoom screen. It's in a different spot than chat, so just know you're looking for a thing that says Q&A. We're going to work to try to get to some of your questions later on. And my apologies in advance if we're not able to get to every question. We've got a pretty big group with us today. So let me jump right in. I'm going to give an introduction to our panelists. First, Dr. Stanley Carlson Thies is joining us today. He's the founder and senior director of the Institutional Religious Freedom Alliance, which is a division of the Center for Public Justice. And as part of this role, Stanley convenes the Coalition to Preserve Religious Freedom, which is a multi-faith alliance of social service, education, and religious freedom organizations that advocates for the religious freedom of faith-based organizations to Congress and to the federal government. Stanley served with the White House Office of Faith-Based and Community Initiatives at its inception in February of 2001, and has worked with the subsequent 4 presidential administrations on the continuation of the faith-based initiatives. And then we're joined by Jedd Medefind, who serves as the president of the Christian Alliance for Orphans, which is a coalition of 200 plus Christian organizations and over 800 plus churches, tasked with equipping Christians to live out effectively the Bible's call to care for orphans and vulnerable children. Prior to this role, Jedd led the White House Office of Faith-Based and Community Initiatives under President George W. Bush. And in this post, he oversaw reform efforts across the government to harness the full strengths of community-based and faith-based organizations as full partners in all federal efforts to aid people in need, from prisoner reentry to global AIDS. So we're gonna get started with a couple of questions. Let me jump right in. Stanley, you first. Could you bring us up to speed? What are the facts of the Fulton versus City of Philadelphia case? Or, what was the dispute between the Catholic Foster Care Agency and the city that ended up at the Supreme Court?
Sure. Like all court cases, it's a little bit complicated. So I want to think about it in 2 layers, and I'll talk about one layer now, and then I think a later question we can talk about the other layer. So this is about the City of Brotherly Love, city government, and Catholic Social Services, or CSS for an abbreviation. It's a dispute in which it's not that CSS had done any particular thing at some moment. And they didn't turn away anybody who was looking for service or anything. In fact, for 200 some years, Catholics in Philadelphia have been providing services for foster kids, kids who need adoption. And CSS had been contracting with the city for more than 50 years. So no difficulties. They've been contracting, never turned away an LGBT couple coming to them. Nobody had come to them. And they said if a couple did come to them that they felt they couldn't serve, they would refer to one of the 20 plus other agencies in the city. So that's kind of the way things have been going. And the city, though, heard a spokesman for the Archdiocese of Philadelphia say, well, because of Catholic teaching about marriage and about families, if an unmarried couple or LGBT married couple, unmarried couple came to Catholic Social Services, they would not be able to certify their home as suitable for fostering a child. And the city heard that. They called in Catholic Social Services and said, hey, we have a non-discrimination policy. You're not allowed to have the view that you have, so you can't be participant in the foster care services anymore. And Catholic Social Services and affiliated parents they've been working with who no longer could foster through them, they sued and they said, wait a second, the Constitution guarantees the right to exercise your faith, and that includes by organizations. we shouldn't lose our ability to work with the city just because we have a view that's different than the one that they have now adopted. The Supreme Court unanimously, that's to say the liberal, what we consider liberal justices, the conservative ones, unanimously said the city was in the wrong and they could not eject Catholic social services from foster care serving in foster care simply because of their religious beliefs and then the policy they carried out. Right near the beginning of their decision, they say that as an initial matter, it's plain that the city's action have burdened CSS's religious exercise by putting it to the choice of curtailing its mission, stopping foster care, or approving relationships inconsistent with its beliefs. Can't put them before that choice. And then at the end of the decision, they say the refusal of Philadelphia to contract with CSS for the provision of foster care services unless it agrees to certify same-sex couples as foster parents can't survive strict scrutiny. It violates the First Amendment. So the city's wrong, Catholic services has to be allowed in. So you saw that phrase in there, strict scrutiny. It's basically the government, if it's going to burden religious exercise, which is, as you know, protected by the Constitution, it has to have a really serious interest, a compelling interest. And it can't have any easier way to deal with its problem than by putting that burden on religious exercise. And the city said, hey, we do have a compelling interest, which is non-discrimination. So with our non-discrimination rule, then more families will come to the table. Actually, the court said, we don't think that's right. You just drove out agency that serves a lot of families. How does that make more families come to the table? And then the city said, well, the rights of LGBT people are really important and we have to vindicate those. That's why we have the non-discrimination policy. And the court said those rights are weighty, but they don't automatically triumph over religious freedom rights. And in fact, in this case, the city should give an exemption to Catholic social services, let them be in its network of all these different kinds of providers. It's unanimous. The justices didn't all agree on exactly the reasons, but they said unanimously, the city has to let Catholic charities back in. I should say that 5 or 6 of the justices said they wanted to overturn the kind of interpretive framework that was at stake in this case, make the religious freedom protections even stronger. But that's not what the decision was about. We'll come back to that a little bit later. But unanimous decision that said the city could not kick out Catholic charities. They have to let them be foster care providers.
Great. Thank you, Stanley, for giving us the quickest overview I've heard so far. It's wonderful. Jedd, I'm going to turn to you, bring you into this conversation. Could you talk about what is positive in this decision for the Christian Alliance for Orphans and its member ministries? And then also, if you could address if you see a negative side to the Supreme Court's action.
Yeah. Well, I would say on the very positive side, when we're talking about foster care organizations that and adoption agencies, these are, folks who have gotten into this work in the first place because they care about people. Most all of them, could make more money elsewhere. There might be more, other opportunities for them, but they are in this because they just want to serve. They want to make a difference for kids. They want to make a difference for struggling families. And they are, for the most part, none of them are political. They're not culture warriors. They're there to serve. And so this case essentially says to them, hey, you keep doing what you're doing. The highest court in the land is here in a way that will generally try to protect you as you do that work. And if a government, whether the city, county level, state level, even federal level, comes in and tries to exclude you simply because you're trying to do your work in ways consistent with your deep religious convictions, then we as the court are going to look very suspiciously at that law or that action. That doesn't mean that there's a blanket right in one direction or the other. I think the court, as Stanley alluded to, is really trying to hold together two what in our society right now seem like incompatible ideas, but I think the court is saying these are actually not incompatible. We can protect the basic dignity and rights of LGBT individuals. We can also protect the basic rights of faith-based organizations to live and serve, including in public systems in ways consistent with our faith. So there was just a strong affirmation of that, both on a more minute legal level, but I think also on a broader cultural message that maybe we can talk about a little more later. So that that really is, I think, the very positive message. And I would see it as almost exclusively positive, because this was not a 5-4 ruling. This was unanimous. And so certainly there were many groups that, very predictably did not like the ruling and posted online and things, reasons why they did not like it. I think most people, with an earnest, honest look at this would just say, like, hey, this is fairly reasonable. If some of the most, conservative and liberal jurists in the country can all come together around an idea that these two ideas of basic protections for human dignity and basic rights, as alongside religious liberty and the ability of faith-based organizations to serve, those things can be held together. They can coexist at a policy level. I think ultimately that really is a net positive all the way across the board.
Thank you. Stanley, do you want to add anything to that?
No, that's great. I
Okay.
think that's right.
All right. Well, going right in there to talk about how commentators have sort of addressed this, I'm going to start with Stanley. Some commentators have called this decision a great victory for religious freedom. Others say it's a really narrow decision, which provides almost no protection, even for Catholic social services themselves. Which view is right?
Of course, it's complicated. I said at the beginning, there are kind of like two levels. So let me kind of talk about the other level. It's kind of in one sense, it's a narrow decision. And it was decided within the framework, the basic framework of the Smith decision, Employment Division versus Smith, a 1990 case in which the court said that religion, the question was, does religion excuse somebody if they do something that's illegal? In that case, it had to do with drug use and in worship, and illegal drugs. And the court said, well, no, you can't just say I've got a religious reason, I can just violate the law. If the law is generally applicable, right, applies to everybody, and doesn't set out to target religious people, then you just have to obey it. And the fact that you have religious arguments, that's kind of like tough luck. Of course, the legislature can step in and make some exception, but if it just kind of on the basic level, tough luck, it's a generally applicable law, nobody's trying to target your religious beliefs, you have to obey it. So that's a Smith decision. A lot of people said that's not quite right. A lot of people said that's not quite right. So just imagine, and this came up in one of the additional opinions in this case, just imagine back in the Prohibition days, if the federal government passed a law that said for the whole United States, no alcoholic beverages could be sold or used, including wine. So we want to get rid of drunkenness, right? So that was kind of the rule. And no exception for communion wine. Then all of a sudden, religions that require the use of wine in like the Eucharist and communion wouldn't be able to practice their religion. But the Constitution says you have to be able to practice your religion. The government can't prevent that. So Smith was just way too broad, and Congress stepped in and they passed the Religious Freedom Restoration Act to try to correct that. But that standard is still there at the Supreme Court. So some of the justices, all the justices said, hey, Catholic Charities has to be reinstated. But some of them said, hey, we have to go further than the decision went. We have to attack the Smith decision. Well, why did Smith even come in here? Well, that's the doctrine that's used. And the city said, if Smith governs, this is a non-discrimination rule, applies to everybody. You can't have a religious reason not to do it. And the court said, no. It actually doesn't apply to everybody, because right in those foster care contracts, the city wrote into it some discretion for the commissioner of social services, who may want to make an exception for the kind of couple involved, or the baby involved, or the child. And so there's an exception built right into the contract. So that means it's not generally applicable. And if it's not generally applicable, then it bumps into this other realm, which is that strict scrutiny that I talked about at the beginning. Is it really an important interest? Is there no other way to achieve the aims of the government? And once it bumped into that realm, the court said, yeah, there is a better way to resolve this that doesn't require kicking out Catholic Charities. So here's the worry that some people have. could the city of Philadelphia just go back and rewrite those contracts so there isn't that chance of exceptions in the contracts? And now they say to Catholic Charities, hey, this really does apply to everybody. That includes you. If you don't want to abide by it, you're out again. Well, of course, what would happen is that court would then end up right back at the Supreme Court. And I think this time the Supreme Court would say, we're going to overrule Smith entirely if they hadn't already done it by now, and just have a new rule that doesn't, and I think the new rule would say something like, even if it applies to everybody, that doesn't make it good enough. It has to accommodate religious freedom unless there's a good reason not to, right? That would be overruling Smith. So it's narrow in a sense, but it's broad in a sense. I want to just refer to those broader things that Jedd alluded to, and you got from the opening question too. The court did not say that religious freedom always triumphs over LGBT rights, but they did say the opposite, the unanimous court, that LGBT rights do not always triumph over religious freedom rights. And that's what they said in this case. You can't just say we have LGBT non-discrimination, so Catholic Charities is out. You have to look at more things than that. So I think that's a really important question. Secondly, this had to do with contracts, and in contracts, the government has a lot of control. So the city of Philadelphia said, yeah, whatever the major doctrines are, still it's contracting. We can control what goes on to make sure we protect the kids and so on. And the Supreme Court said, no, you can't say it's contracting. We want to have a lot of control, so we don't have to care about your constitutional rights. No, there's still constitutional rights, even in that controlled circumstance. I think that's really important for the future. And then there's a pluralism kind of argument that the court came back to right at the end of their decision. They said this: CSS seeks only an accommodation that will allow it to continue serving the children of Philadelphia in a manner consistent with its religious beliefs. It does not seek to impose those beliefs on anybody else. So if they're not seeking to impose their beliefs on anybody else, there are going to be other agencies with other beliefs. Isn't that a kind of situation that we ought to protect instead of saying it's unconstitutional? So I think it's really important, these kinds of elements in there. They ought to just overturn Smith. They didn't do it here. They could already tell the city it was off base, but they said these broader things that I think are really important for religious freedom in this context.
Great, thank you. Got another one, and either of you jump in here. Did the Supreme Court say it's acceptable for a Catholic foster care agency in Philadelphia to deny LGBT people a chance to be foster parents?
I'll go ahead and jump in here.
Yeah.
So this, I think, points to in many ways, one of, if not the core question that has often been wrestled with as this case has been dealt with in the media. Often the primary argument against Catholic Charities has been that if they are allowed to practice in the way that they believe is correct, that will result in same-sex couples being turned away from fostering and adopting, and same-sex couples will not be able to foster and adopt. And the result of that will be there will be children in the system who need families, and they will not be able to reach as many families. But the facts of the case are the reality that the Catholic Charities actually did not turn away a single couple. This was well documented in the case. No couples, same-sex couples, cohabitating couples came to Catholic Charities and asked for those services. And so ultimately, Catholic Charities did not have it within their power, neither in the past, present, nor as a result of this case, to prevent anyone from fostering or adopting. In fact, in Philadelphia, there were more than 24 other agencies who were very glad to place children in unmarried households as well as same-sex households. And so the reality is that Catholic Charities, by specializing in recruiting religious families inspired by their faith to serve, they were simply adding. They were not in any way constricting, they were adding. And so really the fundamental question in this case was not whether same-sex couples could adopt or foster, those sorts of things. It was really, can an organization with what now are minority beliefs about important questions like sexuality and marriage, can they continue to serve children in the public system? That really was what was at stake, and that is what the Supreme Court ruled very decisively on.
Yeah. So I want to just add briefly to that. So it's kind of, it is posed as, if Catholic Charities doesn't serve gay couples, will they be unable to foster? Well, obviously that's not the case, because they hadn't been serving gay couples and there had been all this fostering going on already, right? So there were all these opportunities. And so Catholic Charities was just saying, let us continue to do what we're doing. Everybody else will continue to do what they're doing. And we're not trying to monopolize the whole thing and impose our views. So I think it's really important to kind of get that right. It's the way we deal with religious freedom, right? I can't make everybody be Presbyterians. Nobody can make me be an atheist. But in my Presbyterian church, you're not going to be my atheist pastor. So we just learn to live along together with this diversity of organizations. But, just imagine in this situation, to vindicate the religious freedom rights of Catholic Charities, Catholic Social Services kind of adds to the pluralism, or keeps the pluralism alive. But you can imagine situations where that might not be the case. So just say a community where the only foster care agency has morally conservative values like Catholic Social Services, and nobody else is around, and they just say, hey, we could just do what we want. The court said we can, and that's the end of the story. Well, in effect, that would mean in that community, nobody could foster unless they fit the pattern of that agency. I think that's why it's important for the legislature to step in and say, let's deal with these situations where there isn't pluralism. Let's protect it where there is. Let's make sure it exists every place. So I think that's why we need to kind of think a little bit beyond this. But certainly there's nothing in this case that keeps anybody who's eligible to foster in Philadelphia from being able to foster.
Good, thank you. All right, another one for you. Does this decision prove that the court is now kind of the reliable friend of conservative religious people and organizations? Or should people continue to press for Congress to come up with a solution to kind of these continual conflicts that we're seeing between LGBT rights and morally conservative religious communities?
Well, I'll start with that, and then Stanley, I'm sure you've got good things to add there. I mean, just what you said a moment ago, I think applies to that question already. But I think what we saw so clearly in this case, the fact that we had the full spectrum. I mean, largely the current justices reflect almost the full spectrum of politics in America, and it was a unanimous ruling. So this was not the narrow conservative majority coming to the rescue of conservative organizations. What I believe it was a recognition on the part of the court that true pluralism is possible. In a day and age when our society really feels like it is tearing apart, that people, who disagree even on their favorite baseball team can't be friends anymore, the court is saying, no. These issues that are very hard, yes, they are hard, they are important. We're not diminishing the importance of these questions, but we as the court believe that people still can labor together side by side in public systems for the good of children. And not only can they, but the Constitution requires that the local governments must enable that. And so, while in private association, organizations can, and I would say should, have a very clear sense of what they're about, their values. The ACLU does not want people who are against free expression that are, serving as their board members. It's entirely appropriate that an organization have a strong sense of clear, unified values. When it comes to the public square, where government is setting the table, they have an affirmative obligation to ensure that everyone that is willing to enter that in a respectful way be welcome to do so. And frankly, not only is that required by the Constitution, but this is what's best for children in the foster system. Children are best served when there's a breadth and a diversity of organizations, ones that specialize in different things, that know different sub-communities and can serve and recruit and support those families. And so the Supreme Court this was not, I believe, a conservative statement. This really was a broad vision for the future of America that is very consistent with the best of our past.
Yeah, I agree with that. But I think there does have to be some legislative action. That's just to deal with these situations where there's only one kind of agency, they're vulnerable people and so on. And you can just think of a lot of really important issues, even having to do with adoption foster care agencies that aren't answered. One example is what happens when somebody comes to a Christian ministry, somebody in a gay marriage, for example, and that's not the beliefs of the ministry, and they aren't hired, and then they go and charge that agency with discrimination because of not hiring them. Well, there was a Supreme Court case about LGBT employment rights last year, the Bostock decision, but that was all about a secular employer. And the court said there are a lot of rights for religious employers. We're not going to say how these things apply. So there's something that needs to be resolved. That affects members of CAFO and other faith-based organizations. So there are a lot of things not dealt with here. It shouldn't be necessary for everybody to run to the court on a one-by-one, solve this thing, solve that thing, solve the other thing. When some of these things, I think the court's kind of laying out a roadmap that says you've got to balance these off, and we need Congress to sit down and figure that out. There's a piece of legislation that CPJ's supported, IRFA's supported, Fairness for All, HR 1440, that tries to do that across a wide range of things. I think this case both validates doing that and also says we ought to go ahead and Congress ought to pay attention.
I would just one little thing to add to that, in affirming, and yet, and I know, Stanley, you would agree with this as well, that if we look across the United States, and if the Supreme Court is indeed saying, which I believe it is, that it is very possible to simultaneously ensure a very clear and dignified pathway for any qualified person to be able to foster or adopt on one side, and to allow faith-based organizations to remain faithful to their deepest convictions and continue to serve on the other. And those things can happen together, that the responsibility to ensuring that happens is not the responsibility of any one individual organization. It is the responsibility of government. So if, in the scenario you drew, Stanley, that if there was a community where there were people who were qualified to foster and adopt, but the local agency, for whatever reason, religious conviction or otherwise, was not willing or perhaps was not able to serve them for various nuances, maybe the special needs situations or things like that, it wouldn't be that organization's responsibility to figure out all the ways that they need to be served. It's really the government's responsibility to say, if we are saying they're qualified, then we as government are going to find a way to make sure there's a process for them. That's not on the head of every small nonprofit, every agency that happens to work with government.
Yeah, that's exactly right. Just like it's not on my church to make sure that a mosque teaches its religion faithfully, but the government has to make sure there's freedom for both institutions. So I think that's really important to keep that in mind in these areas of conflict.
And I think there's been models of that in, various programs in the past. That, we're not reinventing the wheel when we're talking about this. It's not just an aspiration, but both of you in your tenure in the faith-based initiative have seen concrete examples of programs that worked exactly that way. Just a reminder to the folks who are joining us today, we've got a couple really good questions in the chat so far, so I'm super excited about that. But just a reminder for those of you that are sitting and listening, I've got about 3 more questions and then we're going to turn to yours. So if you want to drop those in the Q&A at the bottom of your Zoom screen, that'd be great. Couple more questions for you to jump in, as you see fit. So the courts ruled on the side of religious freedom in a series of pretty high-profile cases in recent years. Yet it's also ruled in favor of LGBT rights in important cases, such as making marriage equality the law of the land and reinterpreting federal employment law to protect LGBT employees. Is the Supreme Court being contradictory? Is it being pulled in 2 directions? What's happening?
So I don't want to defend the Supreme Court. They can defend themselves pretty well. What strikes me is that some of these high profile cases, the court's actually saying to everybody else, we have to say yes or no. One side wins, the other side loses. But really, there are interests on both sides. Somebody ought to be paying attention to both sides. And you mentioned the marriage case, that's Obergefell from 2015. Same-sex marriage is constitutional across the whole country. And Justice Kennedy said, that doesn't mean that people who have traditional views of marriage can just be disrespected and disregarded. They have the freedom, they have to have the freedom to follow their beliefs, religiously founded beliefs, their beliefs in traditional marriage. We can't just stifle them. So how do those fit together? They didn't say, but they said both those things are there. Same thing, the Bostock decision you just mentioned, I mentioned it before. Yes, LGBT people can't just be denied employment, but a religious employer has particular rights. What are those rights? They just said there are these rights. The First Amendment's really important for our pluralist society, but they didn't work out exactly how they fit together. I think they're telling Congress, you got to do something. The other case I'll just refer to briefly is Masterpiece Cake Shop from 2018. And in that case, the Supreme Court said the state of Colorado, in the way it treated the Masterpiece Cake Shop owner, it just violated the Constitution by just denigrating his faith and the way he wanted to carry that out. And the government's not allowed to do that. But the government also can't refuse to protect the rights of gay people. But again, they didn't say how they fit together. So the court is trying to say these aren't contradictory. You got to figure out how they fit together. And that's what Congress has got to do.
Yeah, I honestly, right now, I think there's a lot that can be very discouraging. When you turn it on your television, you look at the headlines, social media, even worse, and you just feel like, wow, things are falling apart. And there is a certain sense in which the gravity of our day, I would describe it as centrifugal, meaning gravity is pulling outward and apart. So people who used to gather at a common table, even if they'd have deep differences, they would be around this common table. They could discuss, they could have that time together. They are now pulled to the corners of the room and they're plotting with their smaller and smaller subgroup for self-defense. That is kind of an image of our day. And what the Supreme Court did, I feel like in this case, is they said, everybody come back to the table in the middle of the room. You don't have to agree. You can have, in fact, you can and should have deeply held convictions that may differ with one another in many contexts. However, when it comes to public square, when it comes to public systems and services, you all need to find a way to labor together. And we as the highest court in the land believe that's possible, that we can indeed protect the rights and dignity of LGBT individuals, and we can protect the ability of faith-based organizations to serve in ways consistent with their conviction. And to me, that's immensely encouraging. And it really, to me, it's offering a picture of the future of our country that is very different than the way things feel right now, that we're all just ultimately going to retreat to our corners and constantly be at each other's throats. It looks like a country where people have different opinions, there's different convictions, religions, faiths, beliefs, but there is a certain sense of respectfulness and even a capacity at times to work together for the common good, even amidst real disagreement.
That's great, thank you. Jedd, I'm particularly curious to hear you share a little bit about how you would say a Christian child welfare agency or another faith-based organization that's committed to historical biblical convictions about marriage and sexuality kind of affirm these strong convictions while also showing the public that it works for the good of everyone.
Yeah. Well, a pair of words that we will often use at CAFO is welcome and integrity. Integrity, often those words may actually seem like opposites. Integrity implies a certain internal consistency, the absence of contradiction and hypocrisy internally. And a welcome, of course, you see it just in open arms, right? And it's hospitality, and it's come on over for a meal, and it throws the doors wide open. And those ideas may seem opposite in our culture. And yet we really believe at CAFO that the follower of Christ is going to be doing both. And so when it comes to integrity, that means having a clear internal sense what those deep convictions are, and what an organization, to put in writing, to talk it through, to prayerfully consider what are the things that really matter most to us. Let's put that down in paper. And when you're in the process of bringing in key partners in that, so this would be board members and staff in particular, you're probably saying, we want to share these convictions together. That's integrity. And yet at the same time, to practice welcome, to say, to the fullest extent we can, we really want to throw our arms wide. We want to light a big campfire and invite anyone to warm themselves around that. And so, those two things, can and we believe should come side by side. And so I think the way we prove it more than anything is simply in the actions, that we are out there serving. We continue to do what Christians at their best have been doing for 2,000 years, which is paying special attention to children as well as any other person that are on the margins, that are hurting, and going out and serving, caring for, And now, of course, it becomes most complicated when there are these issues of sexual morality and marriage, and there's a lot of nuances there where we wrestle through it. But the best organizations that I see out there, they are doing this. They are simultaneously articulating clear convictions that are very consistent with historic Christian faith, and yet at the same time they are willing to be present with anyone in some way. It doesn't mean that you always will place a child with any couple. No organization does that, actually. There's not a foster care adoption agency that would just place a child with any particular home. So there are important decisions to be made there in regard to those convictions. But I think that basic stance of holding integrity alongside just the welcome and willingness to love and serve and care for any person, that's what I think ultimately can show the world what our Father's heart is really like.
Stanley, do you have anything to add about the kind of work of faith-based organizations more broadly, and how they can sort of affirm their strong convictions and show the public that they're working for the good of all?
Well, it's actually really important for a faith-based organization to be clear, have that integrity about their convictions, reflect that in their internal operations and so on. What the Supreme Court here did was say, Catholic Charities, we see you've got different views. It's clearly founded on your beliefs, and we're going to protect that. If they had just kind of mishmash things, it wasn't clear where they stood, why they stood, they would not have gotten that kind of protection. So it's really important to be clear about that. But if you do have that love of everybody, I think you're going to be looking for ways to serve along with others wherever possible, to be welcoming people as far as you can, to find ways to contribute to the being a good neighbor as far as possible. And I think that also means standing up for the rights of others who you might disagree with when they get into difficulty with public opinion and even the law. So to say we stand with people, not against them, even if we have somewhat different beliefs, I think that's really important.
So I've got one last question, and then we're going to turn to the questions we've gotten in the chat for really good ones. So Stanley, specifically for you, just in light of the Supreme Court decision, what do you think about the decision of Bethany Christian Services to change its policies about serving LGBT and same-sex married couples?
Yeah, so I'll just make a couple points about that. One of them is Bethany Christian Services in the past ran into difficulty with a lot of different states, and I think they should not have threatened Bethany Christian Services, just like Philadelphia shouldn't have done that with Catholic Social Services. So I'm really sorry when governments wrongly use their coercive power, their money power, to try to coerce agencies to change their well-founded policies. Bethany now has adopted a different policy. They've kind of rethought things. They've changed their practices. It's important for agencies to know what they believe, why they think that's biblical, even if I don't agree with it, to come to a well-considered position and then adopt that. And I think we need to respect that when agencies try to be consistent with those beliefs. We can argue with them. I've done that, but we should respect them in where they've come. Even when we disagree with them, we do that all the time with all kinds of agencies. I want to salute Bethany Christian Services for a lot of years when it invested time and money in trying to persuade states to protect Catholic, Christian, other agencies that have unpopular views about sexuality. So they helped some laws get changed and regulations. I think that was really important that they've done that in the past. They now have a different stand themselves. I just invite them to now stand up for others who have the policies that they used to have. These other agencies now need the protection of religious freedom. I think we all kind of owe it to each other to stand up, even when we don't agree on what those policies are.
Great, thank you. All right, I'm going to turn to these super questions in the chat, and I'm going to try and collapse a few of them. So there's several folks here who've asked about the implications of the ruling that might give hope to other types of organizations. So some that have been named are rescue missions. And the idea here is, rescue missions serve every person that comes to them, but some do not allow same-sex couples to cohabitate, part of their religious beliefs. So are there any implications from this ruling that might give hope to rescue missions in that type of a situation?
You want to start?
Yeah, I'll start. Yeah, so there are implications. I mean, it's a particular court case, right? So the Supreme Court said, here are the circumstances, and this is how we're going to rule. But they also had these it has much broader implications. They said these broader things. I think Jedd was right earlier to say local governments, I think the federal government too, needs to be kind of mindful of this, and to just kind of go and say, we want to protect certain kinds of rights. We're going to apply this blanket across the board, even when agencies have well-founded other views of doing things, or other alternatives, or other ways to protect people. There are other places homeless people could go, and all those things. I think this is kind of a warning shot across the bow of governments that aren't paying attention sufficiently to accommodating religion. Exactly how that's going to work out, we don't know from this decision. I think that's why Congress needs to step in and clarify that. But there's certainly a lot of guidance here that says governments can't just say, for example, you took our money, here's the blanket rule, tough luck, you got to live by it.
Yeah, and I would, as Stanley alluded to earlier, 5, maybe 6 of the justices alluded to the fact that there will be further work needed, and very likely a reworking of the fundamental assumptions about how all this is approached vis-a-vis the Smith standard. And so that is probably coming. In terms of this decision alone, I think it does put governments at every level on notice that if they are excluding faith-based organizations because they're holding unpopular beliefs about marriage and sexuality, that they need to be very careful about how they're approaching that, to try to balance the protection of LGBT individuals with the rights of those religious organizations, and hopefully be able to hold those things side by side. In particular, as it was talking about this kind of idea of a strict scrutiny standard, what the justices reiterated was that if the government creates a policy and then there is any discretion left to government decision makers, any flexibility in that of, hey, this is our general rule, but we can make a little exception when there's a person with special needs, any wiggle room like that, that immediately moves things up to that strict scrutiny standard. And what the Supreme Court is saying is that, hey, if you are allowing yourself any discretion at all, and there's a faith-based organization that's doing good work, they're serving people, but they have this conviction about sexuality or marriage, you need to accommodate them if you're allowing accommodation for any other exceptions to your anti-discrimination rule. And so I think in the short run, it's sending a very important message about trying to hold together the protections for individuals with the rights of faith-based organizations. And in the long run, I think we will see a fundamental reworking of the broader framework.
Yeah.
Great. This question is about the sort of going back to the thread we had earlier around the clarity around organizations communicating their beliefs. Some questions around like your recommendations on where the organization communicates this, right? Is this just an internal within the organization? Is this a website, policies, applications? Like where should organizations be thinking about communicating this information?
So I think it depends on the organization to some extent. So just imagine if it's a college or university, it sends out a lot of information to students about what the classes are going to be like. Are they going to have advisors? Do they get to live in dorms? What are the dorms like? How wonderful your quad is to play Frisbee on, or all kinds of things. That's the time to say, hey, we're a Bible believing organization, college, we have these kinds of standards. You should know that in advance before you decide to come here. I think that's pretty plain. I think it ought to be apparent to somebody who comes to a faith-based organization that they're in a faith-based organization. That's not a secret among the staff. That's made public. Does that mean you say to the whole public, here are the 6,000 things we do and don't do? I don't think so, but you can give some pretty clear guidelines to people that we have certain ways of doing things. We expect that you can expect that's the way we would serve you with integrity. If for some reason we can't do everything that you think it needs to be done, we'll be happy to help you find some other kind of place. So it kind of depends. It's really important in employment for sure that an agency makes it very clear, not just kind of like at the last minute, after saying all our qualifications are, can you work on nights and do your social media, and can you lift 50 pounds, work 40 hours a week? And then kind of at the end of the interview process, oh, by the way, we think the Bible is really important and we think it means something for how you treat people and how you live your life. That's not right. That ought to be right up front if you think it's important. So it kind of depends on the policy, depends a little bit on the organization, but I think it ought to be plain to people that you're not hiding your light under a bushel. That helps them make good choices. It helps protect you if there's an issue. It helps you stay true to your mission. That's really important.
Okay. Someone would love to hear you talk about the application of the case to faith-based organizations where there's not government contracts or interactions, but kind of a posture of we're not trying to impose our beliefs. We're not trying to limit the LGBTQ community, but it's not a fit for our organization to partner together with organizations who affirm same-sex relationships and marriage. Is there anything from this case that's applicable, or the advice more broadly that we've talked about? And is there protection for organizations to be able to say that without it being tagged as discrimination?
Yeah, well, I think the key distinction that the court here and in other cases have made is between, public square type of activities, events, public programs, and then private association amongst individuals and organizations of certain convictions. And this, of course, goes back to the beginning of our country, the idea that in the public square, there should be broad accommodation and participation and welcome for people of all kinds of beliefs and convictions, right? And then in terms of private association, what we refer to as free association, that there is a great deal of latitude and freedom for individuals and organizations to form teams and clubs and groups and coalitions and co-ops with people who share their deepest convictions. So, you think of a group like the ACLU, they would be if they're in the public square, there's certain things that are governing that activity, but in terms of them forming their network and who they work with and those sorts of things, there's a great deal of latitude for them to associate with people who are really passionate about free expression and other particular types of rights. And if people don't share those convictions, hopefully the leadership of the ACLU will treat them respectfully, but they're not obligated to bring them on as board members, staff members, those sorts of things. And so I think that certainly applies here, that if faith-based organizations, I think when it comes to the public square, that stance of welcome and respectfulness, and hopefully even going beyond that, right? As Christians, we believe it's not just tolerating others, it is truly loving them and serving them. I mean, Christ talked about, loving even your adversaries and your enemies. And I think that means, or Paul put it in this words, if your enemy is hungry, feed him. If he's thirsty, give him something to drink. So I think that activity of actively loving, serving, welcoming, caring for people who see things very differently than us, that's what a Christian looks like in the public square. When it comes to forming the convictions of your church, of your organization, I think there is a call to say, okay, what are our deepest convictions and how do we hold integrity to those convictions within our organization? And to finish this, I'll just add this final thought is that, that type of integrity, some people may look down on and say, that's exclusive. But the truth is any organization is going to need to do that if it's going to have anything to offer to the world. If we say our organization is just whoever comes in the door, well, the reality is what you're going to have is just largely something that echoes the values of the broader culture. You won't have anything unique and special and beautiful to offer you other than an echo of what is already probably in excess in the broader culture. It's when people come together with passion and deep conviction and they form those things together, they strengthen one another in that, and then they offer those things to the world, hopefully always in a humble way, but in an earnest and committed way. That is what can bring good to our entire community. That's what our country needs.
Yeah, it's kind of a paradox, I think. If all the organizations just try to be kind of the same, open to everybody, then there's no diversity for us outside those organizations who are looking for some kind of special service, something that really appeals to what's deeply important to us. If we're going to have those choices, we have to let organizations be distinctive. It's really striking. This is a good experiment for somebody. Just go online, go to the People for the Ethical Treatment of Animals website, PETA's website, and they want to make sure that animals are treated fairly. Look at their employment criteria. They say we hire a lot of different kinds of people, but if you're in a public-facing position, like you're going to raise funds for us, you're going to talk to the public about PETA, you have to be vegan 24/7. It makes a lot of sense, if somebody says, hey, I believe in animal rights, and then they go hang out at In-N-Out Burgers, that's not a very good witness. And so PETA has that view. It makes perfect sense to me. Same thing is true for religious organizations. I think one of the ironies in our time we're getting so diverse, it means we run into a lot of different people and organizations that are different than ourselves. And it's really tempting to say, force them all to be like me, because I don't like all their differences. But in this time of differences, exactly when the government has to protect those differences. That's who we are. We do have all these different views. The government shouldn't be trying to smooth them all out. That's just a recipe for causing a lot of difficulty for people who really want to live from their hearts, offer something from their hearts to everybody else. So we have to figure out how to live with our diversity, not try to suppress it.
Great, thank you both. Couple more. Someone shared this question. They said that an argument that was made in their local community against a Christian licensing agency was that that agency provided greater supports for foster families than the secular agencies in the community. Was there any similar argument made around how Catholic Social Services licenses and supports their families? Just a question about the case itself.
Well, I know that is certainly a reality, that often faith-based organizations, because they are able to draw in both private donations beyond whatever the funds they get through government contracts, so they're dealing with more finances often, and then second, they're drawing heavily upon volunteers, drawing out of churches and elsewhere. They can provide a much broader source of wraparound support and other things for the families that are fostering and adopting through them. So that is true, and it has been in a certain odd sense an objection in other communities. I didn't see that in any of the documents I saw with CSS case, but what I did see is a strong affirmation that they were providing excellent service. They were on par or better than those who are their peers, and so they were not being excluded because there was any shortcomings in their service. And I think many would say, arguably, that they were actually providing some wonderful things that other agencies didn't provide.
I think it would be sad if we adopted a policy that any agency that does really better than others, by that reason, disqualifies themselves from being part of the system of help. We need the best agencies we can. So that's an encouragement and a challenge to other agencies to find ways to provide wraparound services, maybe to partner together to find community partners that can add something that maybe they can't themselves, rather than take it the other way around. But I know that argument has been made on occasion. It's been made in the past. I think in the past, early in the 2000s, basically government administrators, I'm glad for this, said, no, that's kind of crazy. We're not going to knock somebody out because they do even better than somebody else.
Thank you. This question is asking about the implications of the case for LGBTQ individuals who are part of the church.
As such, I don't think it has any particular implications. If they're seeking to do fostering, they're Philadelphia, they're going to continue to have all the options they have. I think they'll still have to make the arguments they make inside the church about what they think the Bible teaches that their church doesn't agree with. This is one of a number of difficult things that come up in church communities. What should our stand be? Should it change? On what basis should it change? Do we need to divide? Just because a church is a kind of community that needs to have some consistency, even if out in the public square we have a lot of diversity. I don't think it says anything particular, except that we should all be glad, LGBT, Christians or not, secular citizens, everybody, that the court seems to be pointing a way to say, find a way to live together. You shouldn't be persecuting each other through the law and through our rules.
Great, thanks. This is another technical question about the case. The court just declined to decide whether this lower standard should be applied because CSS contracted with the city. Do you see the lower standard being applied in the future when organizations that contract with the government have their religious freedom infringed?
So in other words, that they could just say Smith applies and it's generally applicable. And
yeah.
Well, for one thing, as Jedd said before, everybody's going to be looking to see if there's any discretion in there. And I just kind of wonder, so let me back up just a little bit. There have been now a series of cases, thanks to COVID-19, in which the courts have had to say, what's it mean to treat equally or to not treat less well religious organizations. And the Supreme Court's been kind of raising that standard up. And they have been saying, you know, discretion, that can happen really easily. And if that's what you're doing, then if we let you have discretion, then it's not really applying to everybody. And then you can't apply this lower standard. So I think that standard of what it means to be treating everybody the same has gotten exceptionally high. This case kind of makes it even higher. And so I think it's harder and harder for, I think, officials to come up with rules, which after all have to apply to pretty diverse circumstances in which they don't transgress that, you know, it actually applies equally to everybody. There are no exceptions kind of rule. I hope governments don't try to play that game, because they ought to allow flexibility, because there are all these different kinds of circumstances, but that means the flexibility ought to apply to providing services in different kinds of ways. We're such a big, diverse country. I don't know why we can't just say it ought to be expected that just like there are service providers that have all these different ways of doing it, there are people out there looking for very different kinds of services. It ought to be our standard way of operating is to incorporate pluralism into the services that we regulate, that we invite into coalitions, that we fund, because that means we're best serving our diverse public.
Our time has gone super fast. And I just want to make sure that I give Jedd an opportunity to put in one last word here. I know Jedd in particular wrote a really wonderful blog post called something about the Supreme Court, you know, basically telling us that Americans can still work together. So I just love to give Jedd an opportunity to say a few more words about kind of summarizing our time today and the message you hope we carry away with us.
Absolutely. Well, thank you. And I appreciate you initiating this, Stephanie, and just being able to do this with Stanley, whom I respect greatly, both of you. Of course, the first thing I would say, and I do think this is so important, particularly for all of those who are inspired by their faith to serve, that while these court cases are immensely significant and will very likely have major implications for our ability to serve in public systems, to partner with government, to serve children, to serve in other spaces as well. And those things are very significant. They're very significant for us. They're significant for society. They're, I think, especially significant for those we're seeking to serve. So these things are immensely significant. But we also know that regardless of what government is doing, we are still called to serve. We're still called to love. We're still called to be present in broken situations. And I trust that whatever the scenarios are, whatever the laws may be, that is what we are called to do and what we can do. And so in many ways, the most important thing of all always does need to come back to our hearts. Are we seeking after Christ to come to know him more deeply, to have his love and grace permeate our character, and then hopefully spill out to every person we meet? And I would say in an especially significant way, those who disagree most with us, that they genuinely would not sense from us just an irritation or an anger at the opinions or positions they hold, but that experience first and foremost, and more than anything else, the fact that we see them as the beloved creature of a loving God. They bear his image. They have inestimable worth because of that. And so we're willing to be a part of their lives and work for their good regardless of anything else. So I think that undergirds everything that we've said today. But then coming back to the case itself, wow, I just truly am encouraged. And I do think it points the way to a future that is not the fractionalism and tribalism and division that is so decisive and defining of today, but it really could be a public square where people, even of very different opinions, can still labor together for the good of children. I think that's very encouraging.
Great. Thank you so much. And I am, Jedd, really grateful to you and the Christian Alliance for Orphans for joining us today. I'm really grateful for all the folks who've been able to be part of this conversation. Thanks for your excellent questions. I'm sorry we weren't able to get to quite all of them, but hopefully I collapsed them all so we got at least some touch on the question you were asking. I would invite you to keep in touch with both the Institutional Religious Freedom Alliance and the Christian Alliance for Orphans. We're going to put those in the chat, and I saw that Deborah, who's running tech for us here, also dropped in the link to that blog post that I mentioned, so thank you for doing that. We're really grateful for your time and your service, and my hope is that today was an encouragement to you, and we'll look forward to our continued conversations in the future. Thanks so much.